How is possession of cocaine charged in Texas? Cocaine is considered a penalty group 1 substance. That's the most serious category of drug offenses we have in Texas. As a result, every potential charge for this offense is a felony. For example, if you have under 1 gram of cocaine, that charge is a state jail felony, meaning the punishment is 180 days in jail, up to 2 years in jail, and up to a $10,000 fine. From there, the levels go up to 3rd degree, 2nd degree, and 1st degree felonies in 1 to 4 gram, 4 to 200 gram, and over 200 gram quantities. Understand also that the prosecution is not required to prove the purity of any substance. In Texas, these drugs, including cocaine, are calculated based on the weight, including any dilutants or adulterants. This highest drug category, penalty group 1, is designated based on 2 criteria. One is this is a highly addictive substance, and the second is there's no accepted medical use for this substance. So when you get those 2 factors together in a drug, it becomes the level of drug that we prosecute the most harshly. These punishment ranges can also be enhanced based on other factors. A common one, for example, is a drug-free zone. So if you're in a drug-free zone, in other words, near a school, then your offense is going to be charged 1 level higher than it would have otherwise been charged. 1 to 4 grams of cocaine is a 3rd degree felony. That means it exposes you from 2 to 10 years in prison. Moving up, you have 2nd degree felonies. This is 4 to 200 grams. If you have 200 to 400 grams, you're now looking at a 1st degree felony. And that would typically be the highest level of felony in Texas. It's 5 years to 99 years in prison and up to a $10,000 fine. However, for cocaine, we have an offense level that's even higher than that. Once you get to over 400 grams, you're looking at an enhanced 1st degree felony, where the minimum time in prison is 10 years and the maximum is life. Understand, for any offense, if your punishment is 10 years or greater, that means a jury could not give you probation. So if you're convicted by a jury of having over 400 grams of cocaine, then probation is not even a possibility. To prove possession in Texas, prosecutors have to prove that the item was in your care, custody, and control. But it doesn't require prosecutors to prove that it was in your exclusive care, custody, or control. That means if an amount of cocaine was found in a vehicle between the driver and the passenger, in theory, the prosecution could charge both the driver and the passenger. Prosecutors can argue that drugs were jointly possessed by more than 1 person. So in an example of drugs that are found in the center console of a vehicle, prosecutors can charge both equally with the same drugs and the same amount of drugs. Any additional circumstantial evidence they have, such as evidence that both people used the drugs, would certainly further their case. Drug charges in Texas are serious. They can carry not only significant felony convictions that can affect your employment and certainly your freedom, they also carry collateral consequences, both direct, including license suspensions, and indirect, like the possibility they would affect your employment. If you've been charged with a drug offense in Texas, give us a call. We can help. Our number is 817-203-2220.